I think one way to make ourselves welcome is to file a motion for a status conference well before the hearing on the motion to suppress. Ask that your motion for discovery of items necessary to litigation of a motion to suppress be taken up at that time by the judge. Tell him how long it's going to take you to do the calculations once you get the records, and move for early production of the discovery that way, or by early return on Rule 17 subpoenas ducus tecum. Well, what if the handler says, actually, what if the dog says, I'm sorry, the handler ate my homework? Well, what if there aren't any follow-up training records or any records of the on-the-job performance of the dog? Well, that was kind of the brilliant thesis of Nancy Hollander and Peter Schoenberg in the Flores and Kennedy's cases. They contended that it was a Franks violation to withhold from the judge that the certifying entity required follow-up training and records, but that this handler had not done any of that, and that should have been shown to the judge when the affidavit for search warrant was written, and for failure to do it, it was a material omission in violation of Franks. The fun thing about that way of litigating a motion to suppress, or a Franks motion, is that if there aren't any on-the-job performance records or follow-up training records, then we all get to try to establish what really happened by what we can dig up, by false alerts that we learn about from brothers and sisters in NORML or NACDL. Or we get to show things from other affidavits for search warrant, or we get to elicit from witnesses what we found out about things that the dog suffers from. And when you do that, as Schoenberg and Nancy Hollander found out in those cases, you get to show the judge just how often the handler's bow wow bobo has boo-boo. Several minutes later on cross-examination, Detective Luann's memory cleared, and he recalled a total of 6 times when no seizable amounts of drugs were found after Bobo had alerted. On redirect, he remembered only 5 times when Bobo had alerted and no seizable items were found. The passage of time seems to have improved Detective Luann's memory. 4 months later, during cross-examination, Detective Luann was able to recall the 13 occasions when Bobo had in fact boo-boo. Well, let's keep in mind, if the courts aren't going to give us the kind of records we need to show how many times the bow wow has boo-booed, there's kind of a reverse strategy that we can use. A strategy that depends not so much on the doggy being a bad doggy, as does it depend upon the doggy being a doggy that is too good. The argument sort of goes like this. Narcotics detection dogs are capable of such sensitivity of the nose that they can detect microscopic quantities of drugs that will otherwise be unknown and imperceptible to their owner. And Judge, studies show that dogs are able to alert to minute traces of drugs found on United States currency, and studies show that virtually the entire money supply of the United States is contaminated with microscopic quantities of cocaine. Therefore, the dog's alert on my client's suitcase doesn't mean anything. All it may mean is that within the item of luggage, there is contained a pair of pants, the pocket of which once contained dangerous United States currency. You can find that argument recognized in some of the cases about forfeiture on United States currency. Because of the general contamination of America's money supply, the fact that a dog alerts to a particular batch of cash does not indicate that the money has been involved in drug trafficking or drug use. In recent years, courts have increasingly questioned the reliability of dog alerts for precisely this reason. Even the DEA memorandum attached to one of the motions in your handout explains it. The results indicate that the Federal Reserve Bank itself may be contaminating the currency through the normal procedures used by the banks. The belts of the United States Federal Reserve must be initially contaminated by currency that has cocaine on it. Then in turn, the belts will contaminate clean currency. Hey, on these grounds, we're going to argue that Wink of the Wonder Dog's alert on the $40,000 in the suitcase in Mr. Kane's trunk is meaningless. That doesn't mean there's justification to go search his Aspen condo for drug records, because that money's like any other money in the United States. Or we're going to argue that it was a Franks violation to withhold from the judge who issued the warrant for the Aspen condo that the handler knew all about the meaninglessness of a dog's alert on United States currency. But beware, the United States government for years has been trying to mount a defense to this argument through Dr. Kenneth Furton, who maintains that narcotics detection dogs don't alert on cocaine. What he says they alert on is that they alert on a byproduct of cocaine, methyl benzoate, which dissipates rather rapidly upon exposure to air. In Dr. Furton's opinion, ergo, if a dog alerts on currency, the currency had to so recently be near large amount of cocaine that it's still capable of giving off the scent of methyl benzoate. I don't know that that's been the basis for any rulings so far, but it seems to me a hard basis to maintain when even the DEA manual on a guide to canine introduction says it's been demonstrated that an experienced canine will not alert to methyl benzoate. And again, if the dog's alerting to methyl benzoate, it may be alerting to the methyl benzoate contained in perfume, bubble gum, or snapdragons. So you see, it's a dog-eat-dog kind of world. I think you want to be the first one on your block to get the prosecutor coming and going. The dog's alert doesn't mean anything because it's a bad dog. The dog's alert doesn't mean anything because it's a doggy that is too good. Let's get what records we can and then make the attack on cross-examination or by a direct examination or a substantial showing in a Franks motion. And while you're doing all that attacking, be sensitive. I mean, remember, it's a mushy, touchy-feely world these days, full of animal rights and political correctness. So when you're doing all of this attacking, be sensitive and inquire after the dog's health, because as some of you may know, when we finally got the long-hoarded veterinary records of Wink of the Wonder Dog, we learned that this sensitive, 98% reliable, near scientific instrument had, while on a frolic and detour with her handler, been kicked in the nose by a horse, causing a crushing wound to her muzzle, with hemorrhaging so profuse that it had to be immobilized, and poor Wink of the Wonder Dog herself habituated to dangerous narcotic drugs. Put on your own dog and pony show and win your motion to suppress for your client. Thank you very much. We started a little late, and I think pulled Geraldine up here. If there's any questions, maybe we can take them up afterwards, just out in the hall, please.